seeing, I can't either, but I can shoot.
Good morning. Terry Roberts for the state of Florida, and I'll apologize in advance if my voice comes and goes a bit. I'm a touch under the weather. What the state's asking for in this case is a reversal of a pretrial suppression of evidence. It was drug evidence located in a car driven by the defendant, the appellee here, Manuel Gomez. This case revolves around a single issue, is the case of New York versus Belton, a 1981 U.S. Supreme Court case. The holding of that said that when a policeman has made a lawful custodial arrest of the occupant of an automobile, he may, as a contemporaneous incident of that arrest, search the passenger compartment of that automobile. It follows from this conclusion that the police may also examine the contents of any containers found within the passenger compartment. Now, in the 26 years since that case came out, this doctrine has been refined and has been called repeatedly by this case and cases around this court and courts around the nation a blanket rule, a straightforward rule, a bright line rule. What Belton stands for is if you have a lawful arrest of a passenger, any occupant of a vehicle, be it driver, passenger, backseat passenger, whomever, and an arrest occurs, a lawful arrest occurs, and there's been no argument that the arrest of the passenger in this case, not Mr. Gomez himself, but his passenger, was lawful pursuant to a warrant, that you can search the car and you can search the contents of the car. The evidence in this case was located in a bag that was right behind the driver's seat, and that should be the end of it. This case, this court in Gilbert, just about a year and a half ago in 2005, again reminded the litigants in that case that this is supposed to be a clear, straightforward rule. I think Gilbert and Smith is a recent second DCA case, are absolutely determinative in this case. I'll take you through the facts. The reason I start with that is that my point is that while we normally start out with the facts, I want to make clear that the state's position is that the facts that this court needs to be concerned with in this case are extremely narrow. Do you have a warrant? Was there a lawful arrest? Was this a search of a passenger compartment or something in the vehicle? And that's all. When the cases say it should not be a case-by-case review, our position is that all of the facts that we go through in the briefs, most of them aren't really material to what this court needs to look at. You just need to see a warrant and a search of a vehicle and a lawful arrest, and that's it. And we've got all that in this case. But to elaborate on some of the facts to be able to discuss the other issues raised by the appellee in the answer brief, the main argument advanced, I think the largest argument in the answer brief, is that this search wasn't contemporaneous, that Belton requires that the search of the vehicle be contemporaneous with the arrest. I'd like to correct the answer brief statement that this search happened at I believe that they say 30 minutes after the arrest in this case. What happened in this case was that the police were searching for a man named Michael Calloway, a known drug dealer who had just relocated to Jacksonville. A coalition of law enforcement officers, a task force, this wasn't just one agency but a multi-agency group, came to a house where they suspected that Mr. Calloway was, observed Mr. Calloway enter the house. A few minutes later, Mr. Gomez, our defendant in this case, pulls up alone in a Chevy Impala, goes into the house, and emerges a few minutes later with Mr. Calloway and a third man who was never identified. Mr. Gomez opens the rear driver's side door of his vehicle where the bag was later found, the bag of drugs. Now, the police couldn't see whether he was holding anything because they were viewing the vehicle from the passenger side, so they could see, you imagine, the shoulder, head area. They can see him open the door, but they can't see his hands, which are at his waist level. But he opens the door as if he's placing something inside. They can see that Mr. Calloway and the other man do not have anything in their hands as they enter from the passenger side. So this bag of drugs was either in the vehicle when Mr. Gomez arrived on the scene with it or placed in the back seat when he opened the car before getting into the vehicle. What What happened next is that the police were waiting for Jacksonville Sheriff's Office vehicle to arrive to conduct the actual pullover, but before they had a chance to do that, Mr. Gomez pulled over the vehicle at a post office. The third man, the backseat passenger, goes into the post office, never to be seen again. Apparently he noticed the red and blue lights and had made a swift departure from the scene. And Mr. Gomez actually emerged from the vehicle and headed towards the trunk. Now, this made the police nervous. Have we been spotted? Is he going for a weapon? They didn't really say that they had a fixed, specific thought of what Mr. Gomez was doing in emerging from the vehicle, but it made them nervous enough that they decided to go ahead and stop waiting for the Jacksonville Sheriff officers to arrive and just go ahead and swarm and arrest everyone. They handcuffed both Mr. Calloway and Mr. Gomez. And then after this, certain things happened in a way that the only witness below, Marshall Johnson, he was the only witness, said was a one-step or step-by-step process. They basically said all the normal things that the case law, cases like Lanier and several cases cited in the reply brief say police can do. They handcuffed everyone for officer safety. They said, who are you? Do you know your passenger is Michael Calloway? Yes, he is. Whose vehicle is this? Is it yours? Mr. Gomez says, no, I'm working on it as a mechanic for someone, and it's in my possession right now, but it's not my car. And then they ask for identification. They do a warrants check, and then the search occurs. The standard in all the cases in the 26 years since Belton have said that the search needs to be roughly contemporaneous with the arrest. Every case cited in the answer brief where the search was not held to be roughly contemporaneous with an arrest involves some dramatic break in the action. A car is removed from the scene, a defendant is removed from the scene. Something dramatic happens. In this case, the evidence is clear and unrebutted that this went one step, two step, three step, and they searched the vehicle. And they arrived on the scene and did all these things and departed from the scene in 30 minutes. There was no 30-minute lag of time between beginning the search. And I want to make clear that the state's position...
Counsel, under Belton, is it relevant what the purpose of the search might be?
Is it relevant what the purpose of the search might be? If you mean for weapons or for contraband, I think that's been passed over by subsequent case law, including Gilbert and Smith. No, and in the Thornton's case in 2004, the United States Supreme Court, they said that you don't have to have a suspicion that there is actually a drug or weapon, although the police in this case had been told Mr. Calloway often did his drug deals armed, so they actually did in this case suspect there were weapons in the vehicle. There weren't, but there were drugs.
He could have been arrested before he ever got into the automobile, right?
He could have, and that's the third issue in the answer brief was, did the police create some sort of exigency? First, I think it's worth noting that the Supreme Court's case Davis versus Washington, 126, Supreme Court at 2266, and the Wren case, WHREN, say that when you have probable cause or a warrant, that's an utter replacement for an exigency, and it also doesn't matter if there was a pretextual stop. Now, there's no finding in this case that there was a pretext. The issue was, should they have not stormed the house rather than waiting for him to emerge in a vehicle? I would challenge anyone.
Well, there was a period when he was out of the house, but not in the vehicle.
Right, and I would challenge anyone to find a case.
So it's your position that it's entirely within the unfettered discretion of law enforcement whether or not to arrest the driver. They're free to wait until Calloway.
I don't know that. Yes, Calloway was the suspect.
Gets in, then they can search Gomez and his car.
I don't think that there's any case that holds that there is a certain time limit or that the police must swarm at the very first opportunity. The cases that are cited under this section of the answer brief are the Bennett and Coolidge cases. The Bennett case, for instance, was something where the police waited 30 days. They didn't have a warrant, but they had some suspicion about some drug activity. They waited 30 days to find a gentleman in his car, and there was no exigency or danger. There's no case that says that you must swarm at the first opportunity. I would also note that on page 29 of the record, Marshall Johnson says they were still waiting for the last vehicle, the Jacksonville Sheriff's Office, to arrive, even at the time when they did swarm, when they were worried about what Mr. Gomez was up to getting out of the vehicle. They were still waiting for the Jacksonville Sheriff's Office. This was, again, the coalition was called FAST, and it was an acronym for a multi-agency task force that were police officers, United States Marshals, and different agency law enforcement officers. But with that, unless there's further questions on this, I'll reserve the amount of my time for rebuttal.
Good morning, may it please the court. My name is William Kent, and I had the privilege of arguing on behalf of Mr. Gomez this morning. I'd like to start by saying that, as the court knows, under the Tipsy Coachman rule, the lower court should be upheld if there's any legal basis for the court's order granting the motion to suppress. I say that because I think it is clear from the record that the parties below didn't address the issue as it should have been addressed. The parties didn't, and it's my first argument in the brief, that the state didn't adequately preserve the Belton issue. There's only one sentence in the argument, and I quoted the state's argument at length to put it in context. There's literally only one sentence that raises the Belton issue in the state's argument to the court below. Instead, the state seemed to be arguing, it's not entirely clear, they said they had two arguments. One was inevitable discovery, which the state's abandoned on this appeal, and the other was that it was reasonable. It was just a generic reasonableness argument that it seemed to be sort of an extension of Terry. And that was the confusion, because the defendant argued it purely as a Terry, a prolonged detention that exceeded the scope of the authorized detention. The Belton case, though, doesn't apply. The Belton case has its limits. It may be a bright line rule, but even bright line...
On the preservation issue, didn't they say it was legal because they had a lawful arrest of Mr. Callaway?
Yes, sir. That was the one sentence, Judge Bolston. Now, the Belton case does require contemporaneous and incident to the arrest. Those words have to have some content. They can't be stretched beyond all boundaries. Obviously, there are some cases that will be on the facts of the case, even though you would not ordinarily engage in a case-by-case, fact-specific analysis of a bright-line rule. There are going to be cases that go outside the rule. This is such a case. I cited Vassy from the Ninth Circuit, 30 minutes. I cited Seals from the Fifth Circuit, although it was dicta in Seals from the Fifth Circuit. It said 30 minutes would have been too long to make it a Belton sniff. In that case, it was before the Supreme Court had authorized sniffs. We don't know from this record. We don't know for sure how long the delay was. We do know that it was unnecessarily delayed. That is, the detention of Mr. Gomez was not incident to the arrest of Mr. Callaway. Mr. Gomez was detained and Mr. Gomez was checked out. The car was checked out, the ownership of the car. The owner of the car was called to confirm what Mr. Gomez said about the ownership of the car. Those were not incident to the arrest of Mr. Callaway, and it certainly wasn't contemporaneous. We don't know. I do know that the defense counsel argued to the trial judge that it was 28 minutes until the detention ripened into the arrest, and the state didn't dispute that. Instead, the state, in their initial brief in this case, waived the time limit issue. They said, I think it's page 20 in footnote 4, that...
All right, so you can say defense counsel stipulated that 28 minutes after the stop, the arrest occurred.
That's my position in effect.
That would be the arrest of Gomez?
The arrest of Gomez. At page 61 of the record.
All right, so the search occurred before then? That's why he was arrested? Right.
It seems to be from the argument at page 61 of the record that the detention ripened in the arrest upon the discovery of the drugs in the back of the car at 28 minutes. That seems to be what Mr. Steinberg argued for Mr. Gomez to the trial judge. And the state did not disagree with that argument below. If I could, I would like to talk about creating the exigency. This is an unusual case. It's not your Belton case. The Belton cases are all, I believe, cases where the police happen upon someone in a car and make an arrest. That is, it's not planned to put the person in the car and then we're going to wait till they're in the car and make the arrest. But instead, the arrest happens to occur while the person's in or about the automobile. This is not that case at all. As I said, it's an objective, and this is not a Wren situation. It's not a Davis situation. But what this is the police had the warrant for Mr. Callaway's arrest. They have the home where they've been told Mr. Callaway's to be found under surveillance by this apprehension task force of marshals, ATF agents, Clay County, St. Johns County, Duval County police officers. So they have quite a team there. They've planned it out. They're planning on arresting the man. They know he's in the home. They apparently saw him go in the home, but the record's not entirely clear. He's in there. Then they see this man drive up with the car. He's inside for 15 to 30 minutes, they testified, the marshal testified. And then he comes out. There was plenty of time to make a decision to execute that warrant. That's what they're there for. Instead, they quite intentionally let him get in the vehicle. As you said, Judge Benton, I mean, can that be? I mean, can you create the exigent circumstance? I agree with the state. Belton says that there's no further exigency required. It's simply the fact that the arrest occurs of an occupant of a vehicle authorizes the police.
So are they somehow constitutionally required to, okay, now he's in a car, we need to constitutionally wait till he's out of the car and wait till he goes into another house? And then there'd be constitutional issues about a house.
Well, they
So
can't.
you can only arrest him when he's not in the house and not in the car. That's kind of, isn't that strange?
No, sir, because it's like the Bennett case. Now, I know Bennett's a little bit unusual, but it's like Bennett and like Coolidge in the sense that in Coolidge, the man's arrested in his home. The police went ahead and searched the car. The United States Supreme Court said you can't do that. That's what this is. If they had done, as Judge Benton said, if they had done what they were there to do, which was arrest this man in the home where they knew he was, they could have never searched the car.
Are you asking us to rule as a matter of constitutional law somehow that the police can't arrest someone who has a warrant for their arrest where they think it's the best place to arrest them at? Is that what the law requires?
No, sir, but you can't take the purpose of the Belton rule, which is to protect a police officer who's on the highway and makes a stop of an automobile, and under the happenstance of those circumstances, is having to make momentary and quick decisions for his officer's safety, that he's going to search that vehicle for his safety. You can't take that rule and then allow the officer to say, well, okay, we're going to wait and let the man get into this car. Now we've got the exigent reason to search that car. That's what I'm saying, and I think the law does.
Was there anything in this record to indicate that there was any purpose whatsoever manifested by the law enforcement that they were going to let him get in the car so they'd have the benefit of searching the car?
No, sir, that's just the objective result.
It was coincident that they timed their arrest at a point where he was in the car.
Coincident, but Judge, we know, right, there's what the thoughts of the officers were not probed in the evidentiary hearing. But we just know from the facts that the officers were there at the house, a SWAT team and apprehension team, to arrest Mr. Calloway.
And we also know that they were waiting on one more agency to appear.
No, sir, that was after they started the tailing of the automobile. At that point, the records show they called the JSO for a marked car to make the stop of the vehicle. They had not been waiting for that agency when they were at the home. Rather, they were ready to arrest at the home. We don't know why, but they did wait.
Now, the bottom line is your position, this is simply not a Belton case.
It's not a Belton case. It's not contemporaneous. It's not incident to the arrest. Now, as I spoke of harmonizing, this is in my fourth argument in the brief, of harmonizing Terry with Belton. I think the court's required to do that in some way, and in effect, that's what the trial judge was doing. The focus was on the prolonged detention. If the Belton search, Judge Paulson, if it were a Belton search, if it's to be authorized under Belton, then it must be contemporaneous and incident. You have an innocent third party, at least innocent until they find the drugs in the car from the search, who's being detained. They can detain Mr. Gomez, the driver of the car, under Belton, but only so long as it's necessary to carry out the commands of Belton. They can't detain Mr. Gomez to start an investigation of Mr. Gomez, and that's what they did, to start an investigation of the car. And then we don't know how long that went on until they decided then to search the car. So that's the harmonization I speak of, and I think that officers, they're familiar with Terry and the Terry standards. It's not an unreasonable application of the Belton rule to harmonize it with Terry. But if they're there to then, they've got an innocent third person, they're detaining that innocent third person's car, they're detaining the innocent third person under Belton, then they must promptly proceed, as cases have said, hard on the heels of the arrest to do the search that they're permitted to do under Belton. Just because they could have done it sooner doesn't mean they're permitted constitutionally to do it later.
Did you find other Belton cases where arrest was pursuant to a warrant? I mean, this is a little bit different than the typical situation where the passenger who's arrested is breaking the law right there in front of the law enforcement's eyes, with the perhaps implicit really being condoned by the driver.
Well, no, Judge Ben, honestly, I didn't do the search in that way. I don't think the state started by saying factors that are important to the warrant. It's not a warrant. A warrant's not required under Belton. It can be simply a probable cause arrest, and then you come under time on something.
But I mean, this is an unusual case because there is a warrant.
There is a warrant, but I don't think
in
it
other words,
affects...
the person who was arrested, his conduct was innocent at the time of the arrest.
Yes, sir. Which would make it even further outside the scope of Belton. One other thought, which is, and I place this in a footnote and then in the brief, I'd ask if the court's not inclined to affirm the trial judge, and given the state of this record, to remand it for further evidentiary hearing, so we could determine exactly when, because I think the exact timing of the when the search and exactly when things happen might be.
Well, we know it was less than 28 minutes, and you don't find a case that shows there's any problem unless it's less than 30 minutes.
That's what I found in the cases, Judge. But I think it's not, I would agree with the state in this sense, it's not the exact amount of time. It's whether the search has proceeded hard on the heels. That is, you can't stop and do something else. And what they did was they stopped and investigated Mr. Gomez here and the car and the ownership of the car and why has he got this car and whose car is it. They called the owner of the car. It would appear that all that happened before they did the search. I don't think they'd be calling the owner of the car to confirm that Mr. Gomez rightfully has his car if they had already searched and found the drugs, because then Mr. Gomez is under arrest for possession of the drugs, so they wouldn't need to check that out. So obviously they're checking out the ownership of the car, tracking down the owner, getting the owner on the phone. They're doing all this. This is not part of Belton. It's not instant to the arrest of Mr. Calloway, because Mr. Calloway has been immediately identified. The marshal said within 1 minute he had confirmed the identity of Mr. Calloway. Thank you.
Well, first, I think I'll address the preservation issue. I know I cited the Casey case in the reply brief. There were actually a few sentences that I believe sufficiently preserved this issue for this court's determination. The first was the quote that I think it's perfectly legal for them, the police, to search the car because they had a lawful arrest of Mr. Calloway. On page 55 of the record, the prosecutor also notes that Mr. Calloway was inside that vehicle when he was arrested, so it was okay to search the vehicle. I think that falls squarely on the Casey facts, where there wasn't a case cited and the prosecutor or state attorney didn't use the phrase incident to arrest. I think we're sufficiently preserved here. The contemporaneous issue, if you look at that Vasey case from the Ninth Circuit, that has been very much narrowed even within the Ninth Circuit. The subsequent cases in the Ninth Circuit, like Weaver, clarified that there has to be an intervening act. The Scott case that's cited in the reply brief says time alone is never dispositive of contemporary, for the contemporaneous.
Were there not intervening acts here? Didn't they seek to discover the ownership of the car and verify it, all of that, and then search it pretty much as an afterthought?
I don't think the search was an afterthought, and if I could reply, I think that the U.S. Marshal stated that it was a standard operating procedure to search the cars in the arrest. And when the argument is made that the purpose of the search was somehow concluded when handcuffs were placed on Mr. Calloway's wrists or when he was identified, I think that completely sweeps away the Belton analysis. The search was part of his arrest. All these, there's several cases where you have to do something with a car, and that's not deemed an intervening act. They did everything that was ordinary to do under cases like Lanier-Bahana, the Reynolds case at 592 Southern 2nd 1082. These were all ordinary police inquiries. And I hope that this court wouldn't look at the fact that there was a warrant in this case as something that hurts the finding that there would be a lawful arrest here. That certainly helps the state's case that there was a warrant for arrest in this case. I see my time is out. So,
you have anything else? Thank you very much.
Thank you very much.
Well, that concludes our cases for today. We'll be in recess until tomorrow morning.